Local news continues to report on contractor disputes escalating into licensing investigations. What most people don't realize is that not every contractor investigation starts the same way, and not every investigation carries the same level of risk. Some investigations are routine, some are complex, and some never result in discipline at all. But when an investigation is triggered by a homeowner complaint, the stakes are usually much higher. And those cases are far more likely to end in real consequences for contractors. Today, I want to break down what actually triggers the board's involvement, why homeowner complaints are treated differently, and how everyday disputes turn into licensing problems. If you're a licensed contractor in North Carolina, this is something you need to understand. The North Carolina Licensing Board for General Contractors opens investigations for a litany of reasons: audits, compliance checks, licensing issues, even internal reviews. But the investigations that most often lead to discipline, fines, or license restrictions tend to have one thing in common: a dissatisfied homeowner who files a formal complaint. And once that happens, the process changes dramatically. Let's clear up a common misconception. The board does not rely solely on homeowner complaints to open investigations. They also investigate licensing compliance issues, unlicensed activities, advertising violations, complaints by permitting departments, and other members of the public. Many of those cases are technical and can get resolved quietly. Homeowner complaints end up being different, because when a homeowner files a complaint, the board isn't just looking at paperwork. They're evaluating whether the public may have been harmed, and that's where disciplinary exposure increases. Homeowner complaints tend to escalate because they usually involve allegations of financial harm, misrepresentation, abandonment, or other unprofessional conduct. Those allegations strike at the heart of the board's mission, which is protection of the public. Even when the contractor believes the dispute is just a disagreement, the board has to take the complaint seriously, especially if documents, payments, or incomplete work are involved. Number one is communication breakdown. So when contractors stop responding, and that can even be temporarily, homeowners often assume that the job's been abandoned, or my money's been misused, or they're being intentionally ignored. That perception alone can push a homeowner to file a complaint. Contract and scope confusion is another big one. And that's where contracts are unclear, or you get a vague scope of work, you get missing change orders, or the biggest one is you get verbal agreements and they're supposed to be replacing written terms. So you want everything in writing, and your change orders and your contracts needs to have your license number on there. When you aren't supposedly meeting expectations and there's a confusion there as far as what those expectations are, that's where a lot of the complaints may arise. So you might have certain expectations and the homeowner might have other ones. So you want to make sure everything is properly documented in writing. So another one is payment-related allegations. So many homeowner complaints involve money, obviously. Payments made without corresponding progress, disputes over retainage, allegations that funds were taken improperly. So even if the contractor believes they're entitled to payment, the appearance of mishandling of funds can trigger deeper investigation. So licensing and scope issues is another thing. Homeowner complaints often uncover technical violations such as project exceeding a license limits, or improper classification, or even work performed outside of the authorized scope. Sometimes they go unnoticed until a homeowner complaint brings everything under review with the licensing board. Why are homeowner complaints treated differently? And how are they treated differently by the GC board? So first off, they are treated differently because their position statement is, we're here to protect the public. Every board says the same exact thing. The GC board says the same thing. And how they're treated differently is it's put into more of a microscope. They're going to get more attention typically than a normal complaint would. They investigate them all the same way, so you're going to have written response deadlines. Those are voluntary. If you want to speak with an investigator, again, that's voluntary. But where it might be different is requests for contracts, payment records, kind of things like that. And if you don't do any sort of response, you just ignore it, then they're only seeing one side of the story. They're only hearing from one person. That's the complainant, the member of the public. So you got to be really careful about how you go about that. The most important takeaway is this: not all investigations are created equal. Most homeowner-initiated complaints are the ones most likely to result in discipline by the North Carolina General Contracting Board. And in most cases, these complaints don't start with intentional misconduct. They start with poor communication, unclear documentation, and delay or improper responses once the board gets involved. Understanding those differences can make it or break it in protecting your license. If you want a deeper look at what happens after a homeowner complaint is filed, including how the investigation unfolds and what contractors should and should not do, I break that down in another video. Watch my video on the North Carolina General Contracting Board complaint process to understand how these cases move from complaint to discipline and how to protect yourself once the board is involved.